Thank you, Mr. Chairman. Good morning to everyone. Thanks to the witnesses for being here. It is indeed a distinguished panel, and I hope we do have some very spirited discussion on all sides of the issue. We're here this morning to examine an issue that is enormously complex, but based on a principle that is remarkably simple. Simply put, today, literally billions, or trillions, as the chairman has pointed out, of dollars of investment savings in participant-directed retirement accounts are being managed by individual plan participants. For the layman in our room, that means that decisions about, say, a 401k investment that will have consequences 5, 10, or 30 years down the road, these decisions are being made by people like you and me, not necessarily by the people sitting down here on the panel, or a colleague or a neighbor, and too often without any sound financial advice on which to base them. Why has this historically been the case? Well, perhaps for many reasons, not the least of which is the fact that for far too long, the ERISA statute, which provides much-needed protections to millions of workers and retirees, stood in the way of workers' access to this advice. Through so-called prohibited transaction requirements in that law, workers were too often unable to access personal, individualized, quality investment advice in the workplace. That's why in 2006, Congress enacted with overwhelming bipartisan support the Pension Protection Act. As you may recall, that bill did many things, but of greatest relevance to today's hearings, it created concrete measures to ensure individual plan participants could have access to the quality investment advice they so desperately needed. Indeed, in some ways, I would argue this provision is even more important today than it was 2.5 years ago. Given our current economic downturn and its repercussions on individuals' retirement savings, the need for quality investment advice is more critical than ever. In the years following the enactment of the Pension Protection Act, and as directed under the law, the Department of Labor issued regulations implementing the investment advice provisions of the Act. While these final regulations were published in January of this year, the effective date of these regulations has been suspended by the incoming Obama administration, as the chairman pointed out. The administration announced last Friday they would continue to solicit comment on whether the regulation should move forward, be suspended, or be otherwise modified. I would hope the department approaches this question in a thoughtful and deliberative manner and does not simply go through the motions to repeal these regulations for political or ill-advised reasons. I suspect we'll hear a lot about the department's regulations today, both from those who support them and those who will criticize them. I think it's important, however, to have a very clear record of what these regulations are and what is not. Some have attempted to characterize these as last-minute midnight regulations stuck into the Federal Register in the last days of the Bush administration without ever having seen the light of day or been given serious scrutiny. Others have characterized these measures as a giveaway to the financial services community that will simply fill the coffers of investment advisors who will be free to provide so-called conflicted investment advice without fear of sanction. Both of these characterizations are simply, I believe, flatly wrong. To refute those who claim this regulation was a last-minute attempt to shove through unseen proposals, I would simply look to the record. The Pension Protection Act, including investment advice provisions, was signed into law in August of 2006. Before the end of that year, in December, the Department of Labor published a request for information from all parties seeking guidance and input as to the shape of regulations under the new law. In August of 2008, the department published proposed regulations, again vetting them for public comment from all stakeholders. Later that year, in October, the department held a public hearing on the proposed rules to which interested members of the public were invited to comment on the proposals and recommend change. Finally, and only after this extensive public vetting process, the department published its final regulations January 21st, 2009, in the Federal Register. Now we can, and frankly I expect we will, debate the wisdom of choices the department made or what was included in these final regulations, but to claim that they were not given full and open debate and consideration is simply to rewrite history. To those who claim the regulation is a parting gift to financial services companies, I again say a check of the facts is in order. I'm anxious to get to the hearing today and to hear from our very, very distinguished panel of witnesses. And I know that you have all been briefed on the rules, and the chairman will brief them again. We've got a lot of ground to cover. And again, I want to thank you for attending today. I yield back.